5 seconds to go. Start. Though the discretion given to the court is very wide, comma, the very width requires a corresponding caution. Stop. In Mohanlal versus Union of India, this court has observed, comma, while considering the scope and ambit of section 311, comma, that the very usage of the words such as, comma, within bracket any court, comma, within bracket at any stage, comma, or within bracket any inquiry or trial or other proceedings, comma, within bracket any person, and within bracket any such person, clearly spells out that the section has expressed in the widest possible terms and do not limit the discretion of the court in any way. Stop. However, comma, as noted above, comma, the very width requires a corresponding caution that the discretionary powers should be invoked as the exigencies of justice require and exercised judiciously with circumspection and consistently with the provisions of the code. Stop. The second part of the section does not allow any discretion but obligates and binds the court to take necessary steps if the fresh evidence to be obtained is essential to the just decision of the case, comma, within bracket essential to an active and alert mind and not to one which is bent to abandon or abdicate. Stop. Object of the section is to enable the court to arrive at the truth irrespective of the fact that the prosecution or the defense has failed to produce some evidence which is necessary for a just and proper disposal of the case. Stop. The power is exercised and the evidence is examined neither to help the prosecution nor the defense, comma, if the court feels that there is a necessity to act in terms of section 311 but only to subserve the cause of justice and public interest. Stop. It is done with an object of getting the evidence in aid of a just decision and to uphold the truth. Stop. Para. It is no doubt true that the accused persons have been acquitted by the trial court and the acquittal has been upheld, comma, but if the acquittal is unmerited and based on tainted evidence, comma, tailored investigation, comma, unprincipled prosecutor and perfunctory trial and evidence of threatened terrorized witnesses, comma, it is no acquittal in the eye of the law and no sanctity or credibility can be attached and given to the so-called findings. Stop. It seems to be nothing but a travesty of truth, comma, fraud on the legal process and the resultant decisions of courts, hyphen, quorum non judice and non est. Stop. There is, comma, therefore, comma, every justification to call for interference in these appeals. Stop. Para. For the above reasons, comma, we have come to the conclusion that the decision of the High Court which is impugned in the appeal is unsustainable. Stop. We accordingly allow the appeal and set aside the impugned judgment and order of the High Court dated 8th April 2022 in miscellaneous criminal case number 57152 of 2021 as well as the order of the second additional sessions judge, comma, Dr. Ambedkar Nagar, comma, District Indore dated 30th November 2021 in Sessions Trial 227 of 2016 dismissing the application filed by the prosecution. Stop.